It's 11 o'clock at night. I got it. If social media platforms like Facebook or YouTube or X tell you to be quiet because they don't like what you have to say, have they violated your free speech? A, yes, because they're kind of like the government. No, they're private companies, not the government. That's B. Or C, maybe. Well, this one might just come down to maybe. I'm sorry, there's no the above option for all of you, remembering your entire high school career. But the Supreme Court is trying to figure this one out. First of all, no, social media companies are not the government. If it were the government, it'd be a different ballgame. Generally speaking, the government has to be what they call content neutral, meaning you cannot censor or punish people based on what they're going to say. But there are those who claim that these companies might as well be considered the government. And Texas and Florida laws say that these companies are censoring conservative voices when deciding what content they can remove from their platforms. But those laws are now before the Supreme Court. And the social media companies argue they, in fact, violate their own speech rights. Now, some justices today appear sympathetic to their argument.
And I wonder, since we're talking about the First Amendment, whether our first concern should be with the state regulating what we have called the modern public.
And it seems like in Buckley in 1976, in a really important sentence in our First Amendment jurisprudence, we said that the concept that the government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment.
So who is right? Well, joining me now, Carl Szabo, VP and General Counsel of NetChoice. That is the company acting as the lead plaintiff and challenging both those laws before the Supreme Court. Carl, so glad you're here. The immediate reaction of people is, hold on, how is a social media company the government, that the First Amendment would actually apply? Your argument is that they're not, and this is out of bounds.
Yeah, you're absolutely right. I mean, if the states Florida and Texas were to take your multiple choice test, I'd say send them back to bed, because they clearly do not understand what they're doing. The First Amendment is pretty clear. It says the government may not force any of us, you, me, CNN, any of us, to say something we do not want to say. And there are plenty of times that people come up and say, I want to be on your show. And you say, no, I don't want to have you on my show. Or you should do the news this way. Well, I don't want to do the news that way. But the state of Florida and Texas are saying the exact same thing to websites. And no, they can't, because that's their First Amendment protected speech. And here you have two states, Florida and Texas, that are actually trying to force websites like Facebook and YouTube, but even sites like Etsy to host content that they don't want to host. It is so crazy that even these laws would require Etsy to be forced to sell sweaters with swastikas on it. They don't want to sell that. Why should they be forced to sell that? That's not in their interest. That's a violation of their First Amendment.
So this comes down in many respects to the idea of censorship. And obviously, it's the government who cannot do that as opposed to private individual. But there are arguments to be made that, and some are making them, no, they should be state actors. Trump famously made this argument several years ago, feeling that he had been censored. When you look at this argument about them being a state actor, is it really coming down to that they are omnipotent or omnipresent in places? That's not enough to be the government.
Yeah, it doesn't work for a number of reasons. One, it doesn't match reality. So if you don't like what's going on Facebook, you can go to YouTube. You don't like YouTube, you go to X. You don't like X, you can go to Truth Social or Rumble, conservative platforms. So it doesn't match the facts. But it doesn't match the law either, because there have been case after case where the famous case, the Miami Herald v. Tornillo, the U.S. Supreme Court said, you know what, even if you are a monopoly, you're still entitled to First Amendment protection. Or you look at a case out of California, PG&E, California PG&E, a public utility, still entitled to First Amendment protections. So there's no way to do an end run around the First Amendment, and that's by design.
Let me ask you, though, coming out of the oral arguments, do you feel confident the Supreme Court will see things your way? It's hard to read the tea leaves sometimes.
Yeah, I mean, sometimes reading tea leaves is way more clear than trying to read 9 justices. But at the end of the day, we have 200 years of First Amendment law saying it is the right of individuals, the right of businesses to decide what content is appropriate for them, and not the government. And at the end of the day, that's what they'll find, that's what they'll decide, and that protects all of us.
Well, I'm out of tea leaves, Carl, but I'm glad you stopped by. We'll see what they actually end up saying. We know they might just take till June. So glad to have you here. Thank you.